Hello, my name is Attorney Ramsey Bahrawy, and welcome to Your Money, Your Life. Today's segment is about the hope that is provided by VA aid and attendance benefits. Seniors are facing unprecedented challenges when planning for their long-term care needs. People are living longer, are more likely to need long-term care, and will face higher health care costs. Recent eligibility restrictions to Medicaid benefits amplify these challenges. If you're a veteran of the military services, you may qualify for what is called aid and attendance benefits. This has become especially important since the passage of the Deficit and Reduction Act of 2005. The aid and attendance veterans benefit can serve as a lifeline to avoid impoverishment as required by Medicaid while retaining adequate medical care. In this regard, veterans benefits can play a crucial role in planning for long-term care. As such, I believe that veterans benefits represent an important piece in the estate planning puzzle. Unfortunately, many veterans or their surviving spouses, and sometimes even their attorneys, are unaware of the qualification requirements for aid and attendance benefits. So allow me to take this opportunity to discuss the 5 basic eligibility requirements for the aid and attendance benefit. They are, first, 90 days of active duty service, of which 1 day was during wartime. Second, limited assets and income. Third, the need for regular assistance from another person. Fourth, the veteran was not dishonorably discharged. And fifth, the claimant is permanently and totally disabled or over the age of 65. So let's discuss each of these requirements in more detail. First, it's obvious that the status as a veteran is a prerequisite to receiving VA aid and attendance benefits. In order to qualify as a veteran, a person must have completed at least 90 days of active military, naval, or air service. Also, at least 1 day of service must have been during a qualifying wartime period. The types of service that qualify are combat duty, active military service, or service as a cadet in a U.S. military academy. Please note, however, that generally speaking, active duty for training does not qualify as active service. Also, the claimant must have been discharged under conditions other than dishonorable. Therefore, it's important to understand that the U.S. military assigns one of 5 discharge categories. These categories are, first, honorable discharge; second, discharge under other than honorable conditions; third, general discharge; fourth, bad conduct discharge; and fifth, dishonorable discharge. It's also important to note that the Secretary of Veterans Affairs retains the discretion to define the term discharge under dishonorable conditions. Therefore, this term can be broad in scope. For example, a discharge under other than honorable conditions may be considered a discharge under dishonorable conditions for VA purposes. On the other hand, a discharge under honorable conditions is binding on the VA. For a listing of specific conditions of discharge that would render a veteran ineligible for benefits, please consult Title 38 of the Code of Federal Regulations. As regards the qualifying wartime period requirement, the periods of war that apply to today's veteran include World War II, the Korean conflict, the Vietnam War, and the Persian Gulf War. As regards the limited assets and income requirement, the VA will not award a pension if the claimant's assets are reasonably sufficient to provide for his or her maintenance. Generally, a claimant cannot receive a pension benefit if his or her countable assets exceed $80,000 or if his or her countable income is equal to or greater than the maximum annual pension rate. Often, however, a claimant can reduce his or her countable income to qualify by subtracting unreimbursed medical expenses. That is our show. As always, thank you to your viewers for watching Your Money, Your Life. My name is Attorney Ramsey Bahrawy, Building Your Trust.